Some of you, please let me know in the chat box if I am clearly visible and audible. All right, then we'll be starting by 5. Thank you. A very good evening, everyone. Welcome to the legal lecture series of Legal Chariot. If you are new to this session, let me introduce you that this is an initiative of the students of University of Allahabad, where we aspire to expand our legal knowledge with the help of experts of this field. And today we are delighted to have with us an oracle of legal fraternity, Senior Advocate Shri Radha Ojha sir. Sir is the elected President and Secretary of Allahabad High Court Bar Association. And today, he'll be sharing with us his valuable inputs on expertizing the skill of advocacy. We all, being attached to this law field, very well know that how much importance this subject holds. Right from the inception of joining this field, we aspire that we should have an expertise over advocacy. So now, without further ado, I would request Sir to initiate the session with lots of gratitude in our hearts for accepting our invitation. The platform is all yours, sir. Thank you.
All are connected?
Yes, sir.
Should I start?
Definitely, sir.
On the screen, people are not visible, therefore I'm saying.
Sir, almost more than 120 students have joined the session, and there is a continuous add-on to the numbers. We can start as of now.
You can start.
Thank you, sir.
Good afternoon. Because I am looking only Sambhui. Nobody is on the screen. Therefore, even behind the screen, I welcome to all of you. Today, Allahabad University students has organized a lecture series on the expertise of advocacy skill. This is very peculiar because ADA is gathered from the topic itself, and who are organizing. They are the students of Allahabad University and connected other students also. Particularly, they are in field of law. They are completing either 5-year course or 3-year course students, and you are all interested in the future to be advocate, or through advocacy you want to develop your career. First thing, you must remember that I am coming from the basic field. In fact, before coming to this word, and if your advocacy is concerned, it will be going the larger prospect. Then you will find that advocacy means refer to the efforts of individual or group to effectively communicate, convey, negotiate, or assert the interest, desire, need, and right of yourself and other persons. Meaning thereby, advocacy word means I am communicating something for myself or on behalf of other person, placing the facts before the person in front of me on my own behalf or on behalf of the sub person who has engaged me as an agent or otherwise. This is the word advocacy means. But advocate means, what is the meaning of advocates there? A person who speaks up for and defend the right of him or herself or of the another person. Means while you are working as an advocate, doing advocacy, then you are defending for yourself. A person can himself appear in the court or otherwise represent his matter before the person, before anybody, any authority or otherwise, then he will be called as in person. But appearing in person, I'll also put their own arguments and other things before the authority or before the court or anything. They himself are also called as advocate or doing advocacy. But it is called an in-person appearance. In legal sense, as we are appearing, it is the advocate who take the matter of other person and on his behalf communicate the issue before the court, for which we are here gathering here, and we are going to uplift our profession. This is the one of the things which we are going. But before coming to that, developing the skill, I am coming to that. What was the history and the of the advocacy or advocates. Before pre-independence era, there was different kind, and we are governed by the Privy Council, which is the highest judicial system. Thereafter, followed by the Supreme Court and High Court in the different parts. High courts, basically, high courts were there like in Calcutta, Chennai, Bombay, Allahabad. As we in 2015 and 16, we have completed the sesquicentennial year of the Allahabad High Court. Means 150 years we had completed. Now 155 years are there. And in that time, these persons who are doing this noble profession, they were called as wakil, pleader, counsel, and also in the persons who are working as even they are not having law degree. This was not necessary at that time. Who has a certain period has worked as such, they are called as pleaders. They can appear before the court and do these things. But thereafter, after independence, all India advocates has been passed by the parliament, under which proceedings, proper procedure has been provided, qualification has been fixed, enrollment has been fixed, duties have been defined, working has been defined, character and behavior have been defined, and thereafter there is also in each district, in states, under the same act, separate acts has also been passed, as in UP Bar Council Act. Sorry. Therefore, we are the persons who are, after completing the law degree, LLB, 5 years or 3 years, it may be called in different name. Now, like in the BLLB, LLB, 5 years, then BTech LLB, BCom LLB, but they are all the live students who cleared their 5 year or 3 year course. They are enrolled and registered with the UP Bar Council, which is the body at the state level to enroll the members after verifying the certificate, etc. By going through the documents verification, etc. There is also certain conditions that have been imposed, and the Supreme Court and High Court has taken very seriously the issue that one must not be a criminal intended person having no criminal history behind him. Only he can be enrolled as a member of the bar. Secondly, the most important which we are facing and also is the person who is want to be enrolled. He has to give an affidavit that while he is working as an after being enrollment as a member of UP Bar Council, and after registration he will not involve in other profession. Two, we are getting certain defects that by concealing all these things, several advocates are involved in other activities like in state property dealing or some other business and professions. This is not permissible. But instead of the aforesaid fact, members are being enrolled with UP Bar Council. They are now practicing in the different high courts, lower courts, and different tribunals, and other places where the pleaders being advocates are being allowed. The question which I feel that the problem, the points today we are in discussing, that how we should get expertise in and the skill while dealing with the matter. For the aforesaid purposes, first you must learn. You must know that an advocate, to get expertise over the matter, must go through these are the some basic norms first has to be followed. One is that you must go and study the act and the provision, if a client is coming before you, you must go with the fact A. You must be the master of the fact if it is coming to you and client coming to you. Go with the fact. Then after going through the fact, see under which provision of law or the act the matter is coming. Go with the bare act and the provision dealing with the same. Like I'm giving the very pretty example, like easementary rights are there, easementary act. Then what are the rights has been given to the person? To what extent they can have a right over the problem which they had raised before you or to put the fact before you. Like a person has right of path, right of air, right of light, but it is not absolute power, right with and interfering the right of others you are enjoying. Like for the right to go on your land, this is easementary rights. But if you have one way, you cannot say that you have several ways for the same. There must be several paths for the same. If you have one way, that is good enough. It is easementary rights. You must know what is the law, what's your limitation. Like come to the constitution. A person has been terminated, or a license has been terminated. Then see, go through the provision under which provision of law person is lying in service law. There is a series of the different categories of the service law, but basically there is all India service menu, all India service, and there is also civil services and appeal rules, etc. Those are competent for the government service. But in the private, in the university, in the colleges, there is different type of the acts and the rules are there. So if a client is coming to you, first go with the fact, then go with the rule, and then come to the point that which provision of the rule has been violated. And thereafter come to the provision of the constitutions, like Article 14, like 16, 17, 21, in miscellaneous matters, habeas corpus 21, Article 21, right of speech, Article 19. What are the limitations are there, and to what extent your right is there? And thereafter, after going on these points, go with the judgments delivered on the aforesaid point by the court. Either the Supreme Court or of the high courts or even other high courts. Not only the high court in which you are residing there, like in Allahabad High Court. Even the other high courts gives you a lot of benefit to all of you while meeting the problem of the client. This is the basic things which you have to go through. Discuss with your client. But before that, the first primary issue while you are studying as a student, because I was also the student of Allahabad University. Unfortunately, I have taken the law subject in IAS. If you are not, please, I request all of the students who are hearing me, during the course of study, go with all the provisions of the CPC, CRPC, IPC, Evidence Act, and even the other model laws that like cyber crime, etc., which are coming here, Constitution. For the purposes to be the best advocate or the top advocates of the state or the India, if you are not with the well acquainted with the basic laws, procedural laws, evidence values, you cannot be the good advocate as such. It may not necessary that you are coming in the practicing the high court. There may be little requirement of, or sometimes there is no requirement of the evidence and the CPC. Reason is that if you are in the red jurisdiction is there. But the basic law of the red jurisdiction or otherwise completely based on the provision of the CPC, CRPC in the criminal side, Evidence Act. All these are common laws there. In fact, CPC, CRPC, evidence, these are the basic laws in the procedural matter. And if you are well acquainted with the provision of the same, you can do better in the system. You can do better and you can assist to the court in the aforesaid field. Therefore, for the purposes to be the best advocate, one must have at least they have good and the best effort should be made by them to sitting on the chair. First thing, whether you have a case or not, you sit on your chair in the chamber or in the with the junior, with the senior, which where you are practicing, with whom you are practicing, and sit at least minimum 6 hours in whole of the day for the purposes of study. There is no shortcut in this profession, either in the civil court also. You can be the top and you can go ahead only if you have a habit to sitting in the chamber for about 4, 5, 6 hours minimum. Second thing which is very important is that I have stated to all of you that you must have the basic knowledge of the common perception of the law. Conceiving the law by a person, like you may remember it, what a general person is thinking over the issue. First go on this, don't go on the legal points. On the facts, what a general person is conceiving the same and receiving the same on their mind. First think in this manner. Thereafter go on the legal points. Thereafter go place the facts and the rules on that. And then you study with the legal profession, legal laws, judgment delivered by the courts, etc. I would like to inform all of you that for expertizing in a field, you must not only go with the legal points, but the philosophy which is going behind it. Like in the service law, service jurisprudence is very much necessary before you become the expert in the service laws. If you are going through the CPC, if you are being in the civil law, like in the first appeal, second appeal, either in the trial in the lower courts, if you are not well versed with the provision of the CPC, CRPC, and other procedure laws, you cannot be the best advocate so far in the lower court is itself. Like in the revenue matters, if you are going to the practice in their field, for the purposes you have to go. Earlier it was UP Zamindari Land Reform Act and Revenue Acts. Now there is a consolidation Revenue Acts and new act has been there. There must be all provisions should be on your tips, and at least the basic law relating to the revenue law, revenue matters, you must be acquainted. But revenue is not alone, you must know, because the revenue is related with the DDC matters, consolidation proceedings. Revenue matters is also tenancy, transfer of property act. And also in the revenue matters, if you are studying, then it is the easementary rights are also sometimes come into the picture. Only one law, if you are choosing a field, like I am stating that in service side, in civil laws, in the criminal side, now new law has been came, like cyber crime, environmental laws. For the aforesaid purposes, you must come from the bottom. Go with the bottom basic law, and also I want to inform all of you, don't only on the bookish knowledge. Me, like when I entered in the profession, basically I have the petty cases of the service law, revenue law, because the youngsters, young persons who are coming in the profession, they are not be given the risky cases, rather the petty cases are being given to them. But when you are discussing the petty case with a person, small cases, then the person who is sitting in front of you, he must know that the advocate who is sitting and taking this petty and small case, he is well acquainted with the facts, even if the large or the big cases are coming before him. This confidence you have to provide in the mind of the client. How can you do it? You can only do if you have a conversation with the basic norms, like I have said you in the cyber law or in the revenue matters. Kindly come to first revenue, because probably I am feeling that all my students who are here, they are belonging to the village side and they might be come from the village side. So revenue law is very important. When you are going in at your village side, sit with your grandfather, sit with your persons who are having the good knowledge on the field. Even in the lower court advocates, sit with them. You will find with the discussions what is the basic, even things which are not given in the book, even the rule, even the manual, that will be provided by given the knowledge by the persons who are with whom you are sitting, who are elderly person with you. Like in the cyber crime, yesterday with the cyber expert, here in this case, my ex PCBN, he came to me. He is now in the Lucknow, posted as a SP cyber crime or SSP cyber crime. Mr. Rai is there. He has given so many things which we are not aware. Like he has told me, I don't know that we are not, if we are going through the provision, I can go with the cyber crime related provisions. But the basic thing is that you are banking, you are running your account, then first inform to the banking account, your manager, that there will be no electronic transaction, and restrict the electronic transaction except in one account where you have having the very petty amount. This thing was not in our knowledge. You can lose so many things. Now the cyber crime as it is going on, by their assistance, I have organized a seminar in the High Court, presided by one of the judges of the High Court, and about more than 500 my brother colleagues were there. So many clues he has given to me, which we are not even it is not in book. Similarly, I have just stated you that if you are given the civil law, start and having interested to go in the civil services, in the civil laws, like in the first appeal, second appeal, revision, etc. Then you have to first go with the lower court for a few times and get the basic knowledge of the same. And thereafter come to that, go with the pretty small things which are necessary. It may not necessary. I'm just giving, it may not be today important for you. I'm saying that one things which I had studied at the time when I was preparing for the IAS, a case came in the second appeal. I was engaged as a counsel. It came in my mind that yes, this point is there, I have read somewhere. And after about 3 hours in between, I was thinking, it come to that in the evidence, this provision is there. I searched it, I found it, and then this case was admitted. For the purposes of expertise in the field of the legal profession, there is an enormous field is there. And for the aforesaid purposes, to being an advocate, you are entering in this field being advocate. I am coming, some other fields are also there, but I'm coming first. If you are joining the bar, if you are interested to join is the lower court, high court, Supreme Court, anywhere you are joining, then one thing is very important. I have stated that don't feel that I am a topper, or I had just as I have stated that I appeared and twice in the IAS I qualified. I couldn't get success. It does not mean that I'm on this level. Put yourself at the bottom. In something I say, sometimes I am just informing to all of you. I have told so many times to my younger brothers that the advocate goes in the 3 feet behind the level. He from the level, from the in a pit, he see the if he will see the at the top, he will see only sky. Otherwise, the class 3 at the bottom, class 2 2 feet, class 1 10 feet above from the place. But advocate is behind the base. He is 3 feet 4 feet in the pit is there. But if he will see at the top, and there is a sky. Therefore, you all have place. You have you all have right, and you are also have a chance to go at the height which one cannot attain now. Therefore, I request all of you, for the purposes of being taking expertise in this field, in the profession. Now there is also several fields are there. I would like to, if you are doing this thing, if not interested to come in the field of the advocacy as such, even then you have so many fields are there. If 5-year course which are there, and in that there is also new laws is there. You can be the employee in the as a legal officer. You can be the judicial officer. You can be also the every companies, big companies are engaging the councils, not as a council, having legal expert in their company, so that because everywhere law is there, and if law is there, then it can be properly be handled only if the person having the law knowledge. For all these things, even if we are going in the not adopting this legal profession, coming in the as advocate or the lower court or the high court or Supreme Court, if you are interested to the taking job in other field, like you are joining the being selected as a municipal magistrate, even in this field, if you are interested to, if you are joined as a municipal magistrate, you must take habit to go with the basic knowledge of the law, study in the chamber, go with the legal provision first, thereafter come with the provision up to the top of the constitution, because the one thing I want to give in the hierarchy, the government orders are the facts there, then government orders there, then there is rules are there, then acts are there, then at the top it is the constitution is there. From all above thing is the justice is required, which will be done by the magistrate or the high court and judges of the high court and the Supreme Court. I will deal it separately. It is not necessary, this issue is not there, but under Article 142, the Supreme Court can pass any order for the end of justice. But apart from the force fact, if you are choosing to the magistrate, you can be the good judge. You can elevate it as the judge of the Supreme Court or the High Court, being the even joining as a municipal magistrate, the lower level, or a JS as the higher level. But if it can be only possible, then if you are having one, I am repeating this thing, that you have a habit to sitting in the chamber, going with the bare acts, going with the facts, and thereafter applying the same by open minds, and also discussing the issue with the even the Raman man who are having no knowledge, come to the point that whether what if on this aspect what a general person is thinking over the issue. If you are adapting, certainly you can go ahead and you will achieve the goal for which you are there. Anything else do you want? Any question? Because I'm not looking anybody, I'm just speaking to all of you. Any question?
Yes, sir. I have a question.
Yes, please.
Sir, as I'm a student of Allahabad University and I have a moot there in my college. So, sir, how to deal with the moot problems?
Please again repeat.
Sir, I have a moot problem.
Please again repeat your query.
Sir, I have a moot competition in my college and I'm a first year student. So it's very difficult with the moot problem. So can you give some tips to deal with that?
Yes, certainly.
Yes, my same question.
Yes. May I reply the query made just now, the question which was, if you are appearing the moot court, or moot in the moot courts,
yes, sir.
what are the points then, because I had already presided the moot courts so many times, what are the problem which on which topic you have been now wanted to address the same? If you have some topic has been given to you, assuming a topic was given, then this topic relates to which provision of law? Like either if he was given to go on the equality before law in the constitution, in the general trend, I'm saying to you, equality before law, Article 14, equality before law, equal protection of law. Then what is difference between the equality before law? What is meaning of equality before law, equal protection of law? One thing for being appearing in the moot court or appearing as an advocate, if you are on a point, you are there before any system like moot court or in the high court, or in the court of law, fact must be very much clear. The provision of law must be very much clear. And all legal provisions and the lacunas must be in your mind. You can win the moot court, you can have a prize, but only when you are well acquainted with the topic, a legal preposition of law behind it, and the problem which was made before you. Anything more?
Thank you, sir.
Please. Please.
Yes, sir. I have a question.
Please.
Sir, I'm of 3-year program. Sir, my question is that how to consider our growth in this profession, sir? How can we get the clients and how can we deal with that? So, how can I explore the field of advocacy?
Yes, this is right. Very truly, this is a total theme behind your this today's topic is also. There is no shortcut in this profession. One thing you may remember. I have already stated. अगर आप लोगों को कोई प्रॉब्लम नहीं है, मतलब हमको नहीं है, आई कैन स्पीक इंग्लिश, अगर हिंदी में भी आपको बता दें एक चीज, यहाँ पे कोई शॉर्टकट नहीं है बेटा. और वकील को जब शुरुआती वकालत कोई करता है तो उसको बड़े सावधानी से अपने दिमाग में रखना है कि मुझे यहाँ का सबसे बड़ा वकील बनना है. मैंने भी ऐसी दिमाग के रख करके हाई कोर्ट की वकालत शुरू किया. मैंने 3 अटेम्प्ट आईएएस दिया, नहीं हुआ तो मैंने वकालत ज्वाइन कर लिया. आई हैड नेवर अपीयर्ड इन अदर एग्जामिनेशन. मैं आपसे इसलिए कह रहा हूं कि शुरू के दिनों में वकालत में अगर आपने पेशेंस रखा है, यू हैव ए पेशेंस while in your initial stage of advocacy. Now question is how case will come. I'm giving example to you. I had challenged the 73rd amendment made by Rajiv Gandhi in the Panchayat. Particularly, I had challenged the provision that post of Pradhan cannot be reserved. The head of the institute is a alone post, it cannot be reserved. This was the topic I had challenged it. I had studied it about 10 days on this issue. And I challenged it to the Court of Justice, then Justice R.S. Sharma and Justice Markande Karju. After hearing his issue notice to, and it has gone to the all India level. For the first time, it is what I had challenged it. You will get the name, I get the name. Certainly, slow and slow. I don't know how I became this, I got this height. But the thing is that if you are steadily, with a open mind, peacefully, having patience working as advocate, you will get success in the future. No advocate can cry. And one thing I want to all of you, that if you are sincerely practicing either in the lower court or in the high court or in the Supreme Court and is patiently going through, then certainly you will get success. A, there will be no scarcity on your part. It may be there that sometimes to what extent, to what height you will get, it depends on your luck, but certainly you will get more. And so far as client is concerned, if you are giving the result of the case, doing hard work, I have stated all of you. May I just, I'm giving one example to all of you. In one case, my client has given me 3,500 rupees. At that time, it was fees to mine in 1995. I got defeated. He was there for about 10 to 15 days. So he take back from me 1,000 rupees. Very well. I lost the case. So I had given the file. The man has gone. He has praised me here कि साहब आपने बहुत अच्छा काम किया हमारे लिए और सब कुछ किया, मेहनत किया, नहीं जज साहब ने दिया. मेरी ये वो नहीं हिम्मत हुई कि मैं उससे पैसा रिटर्न मांग लूं कि भाई 1,000 आपने दिया, उसको भेजो. वो यहाँ से गया. He was so much pleased with me that after about 2 months I received 1,000 money order. तब होता था money order दिया. So there is no shortcut, but if you're doing it and performing and giving the performance over the matter, and the client has faith on you, certainly one day you will get the. Please.
Sir, I have one more question, sir.
Please.
Sir, how important is the supervision of senior in this profession, sir?
It's very
how important is that?
It's very important. If you got bad chamber, you will get because there is a training, like you may say that in initial stage, if there is a child, then its first hero is the mother and father.
Yes.
For the child, if you will ask and you will study, it is the mother and father is the hero. Similarly, for the junior, it is their senior who are said to be the guide, who are said to be the path maker, and who is also, if his whole character will give the reflection over their juniors. So by choosing, you must be careful that you must get a good chamber where there is a good atmosphere. Case है नहीं महत्वपूर्ण, pardon, केस है कि नहीं ये महत्वपूर्ण नहीं है, कैसा एटमॉस्फेयर है वहां पे, कैसे आपको स्टडी के बारे में किया जाए, कैसे आपको इनकरेज किया जा रहा है कि एडवोकेसी. लाइक आई हैड जॉइंड द चैम्बर ऑफ मिस्टर राकेश द्विवेदी एंड दिनेश द्विवेदी, बोथ आर देयर इन प्रैक्टिसिंग, नाउ दे लेफ्ट टू द सुप्रीम कोर्ट. When I entered in chamber, I got a good atmosphere that there is, yes, this is great advocacy is there. They had given me much opportunity because his father was also the initial advocate. Thereafter, he was the judge of the Supreme Court. Unfortunately, during his tenure, he got expired because of some disease. So I appeared even their cases, which was filed by the father of the Mr. My senior. But the chamber is very important. Neither you will get the first learning is the chamber. And if chamber you got, then certainly you will go through. That is my perception.
And sir, is it necessary that we should practice at the district court at first when we start our career, or we can directly move to the high court for Supreme Courts?
If you need, this is not necessary that you must go, but if you have a time then and have an experience about a year at least in the lower court, then it will be boost for you. Like I had never attended that. I'm sorry. I had never gone to the Kachehri or the lower court. I stayed away, came to the high court. But I have good rapport with the member of the lower court advocates. So if there is some problem is coming, the basic, like initially, now I'm doing practice in the service and the miscellaneous and civil side. I'm not going in the criminal side, but earlier I have also practiced in the criminal side also. So the basics which are not, I am not aware. I asked to the senior brothers who are there in the lower court and got the information, the correct legal proposition of law. But if you have a time, then at least 6 months to 1 year, if you are in the spending your term in the Kachehri, then it will be boost for you.
And sir, like we are studying in University of Allahabad and we come from different parts of Uttar Pradesh. In fact, we come from different parts of India. So is it necessary that we have to practice in our own district court, or we can move to any district court situated in any parts of our...
Okay, you must know that the CPC is the common, IPC is the common, CRPC is the common, except some changes made at the state level. What I am saying, if you are practicing in the lower court for few years, 1 or 2 years, then what is the basic things which you cannot attain unless you have a practical knowledge? Or like me, I had attended so many times. I attended with my brothers in the low Kachehri. I had gone, visited, and I heard. Initially, I was not aware that I will go in the civil side. Then I attended the similar some criminal trial in the Kachehri also. Some cases. So it is for the basic anywhere in country. The basic law of knowledge, presentation of the knowledge, and the basic what is the, if you are practicing particularly in the civil side means the basic civil side, like in first appeal, second appeal, revision, second, etc. Then you must have the knowledge of the lower court proceeding. Like in the criminal side, if you are doing the trial in our high court or the Supreme Court, who are the best criminal advocates, they might have gone in this lower court in their trial, and they had practiced with the trial, and they are also contested the case in the lower court, because the basic some things which you cannot get the knowledge while in the high court or the Supreme Court, and this knowledge you can get in the lower court. But it's not necessary in the Allahabad or others. You can even in the other district courts of this country.
Sir, and you are a respected lawyer in the High Court of Allahabad, sir. I have a humble, what we can say, a request, sir, that can the seniors like you can welcome freshers like us with a warm... Can you welcome us, like we can come to you and we can study law and we can see different types of cases?
Sometimes in our high court, like us, I always welcome to my juniors. I give assistance to them. Even if I am going through on the in the corridor, if juniors are coming, I always advise him, give me the... Sometimes the seniors problem is that if assuming I have 10 junior So scarcity of the space, etc. It may, and otherwise every lawyer is welcomed in the High Court or the otherwise places. We welcome, because you are all
Thank you,
future
sir.
of. Today I am here, I am at the top. Someone in future, someone will be at the top. So I welcome my juniors. You are all my futures.
गुड इवनिंग सर, मेरा नाम शिव कुमार है सर, फाइनल ईयर का स्टूडेंट हूँ सर। मैं ये जानना चाह रहा हूँ कि हाई कोर्ट में स्टार्टिंग में हाई कोर्ट में प्रैक्टिस करनी चाहिए या कचहरी में, और दूसरा मेरा क्वेश्चन ये है कि सर कौन सा फील्ड अप्लाई लेना चाहिए, क्रिमिनल या सिविल या फिर ये रेवेन्यू का या फिर फैमिली का।
आपको किस में आनंद आता है?
सर समझ में नहीं आ रहा है, आता तो है क्रिमिनल का, लेकिन अभी कुछ डिसाइड नहीं कर पा रहे हैं सर।
नहीं, ऐसा होता है कि जब मैं स्वतः शुरू में आया यहाँ पे, तो मैंने भी क्रिमिनल साइड में प्रैक्टिस किया, क्योंकि शुरू में आपको मुकदमे बड़े मिलेंगे ही नहीं, माइनर बेल मिलेगी या छोटे मुकदमे मिलेंगे, क्योंकि कोई रिस्क नहीं लेना चाहता है ना हाई कोर्ट लेवल पे। तो पहली चीज तो आपको मैंने अभी बताया, हमारे जो अभी इसके पहले हमारे छोटे भाई ने प्रश्न किया था, अगर आपके पास टाइम है, अर्ली स्टेज पे आ रहे हैं, तो अगर आप 6 महीने साल भर कचहरी में बैठ करके बेसिक नॉलेज नथी करना। अब जैसे क्या होता है, वी आर नॉट अवेयर हाउ शुड आई रीड विद द पेजिंग ऑफ द लोअर कोर्ट इन द इफ यू सेकंड अपील ऑफ द ट्रायल। तो अगर आपने उस सबको सीख लिया तो कोई बुराई नहीं है, वो अच्छी चीज होगी। इट विल बी द बूस्ट फॉर ऑल ऑफ यू। ए बी, आपको किस सेक्शन में जाना है, ये आप वहां बहुत डिटरमिन मत करिए। स्टार्ट योर प्रैक्टिस wherever you are interested, either in the lower court or high court, and with the time, with your interest, with the case in which you are getting, you will get the path. I don't know then how became in the service law. In fact, my senior was saying that I'm an expert in the revenue side, but up today for more than 10 and 15 years I be a rare case in the revenue side, because it is the kacheri based matter is there. This is the situation. Don't be in this issue. Do बी ओमनीबोरस। ओमनीबोरस समझते हैं ना, सर्वभक्षी, सब केस के लिए।
यस सर।
किसी के लिए ना करिए जिसमें मैटर आपके पास मुकदमे आ जाए, उसको शुरू करिए। एक वकील को कभी ये नहीं कहना चाहिए मुझे मुकदमा नहीं आता है। अरे मुकदमा तैयारी जानते क्या है? फैक्ट आया, आपने पढ़ा, मैंने अभी आपको बताया, फैक्ट देख लिया, अब किसका है? रेवेन्यू का है, रेवेन्यू किताब खोल लीजिए, उसको बेयर एक्ट पढ़ लीजिए, फैक्ट के हिसाब से बेयर एक्ट कहाँ अप्लाई करता है, उस प्रोविजन पे फिर केस लॉ खोज लीजिए, लाइब्रेरी से बैठिए, केस लॉ खोज लीजिए, केस लॉ लगाइए, उसको टेस्ट करिए, बहस करिए। उसमें प्रॉब्लम थोड़ा है, जिधर आपको मुकदमा ज्यादा मिल जाएगा उस सब आपके बड़े वकील हो जाएंगे, इसमें कोई प्रॉब्लम। बट डोंट पुट द बैरियर कि हम यही करेंगे। हमने क्रिमिनल में बहुत काम किया, आज क्रिमिनल में मैं जाता ही नहीं हूँ।
ओके सर,
ओके,
थैंक यू सर, थैंक यू सो मच सर।
सर, और मास्टर्स करना क्या एडवोकेसी करियर के लिए फायदेमंद होता है या फिर बस एलएलबी पे ही शुरुआत कर सकते हैं?
नहीं, एक चीज आपको बताएं, देखिए जैसे आपको मैं बताना जा रहा हूँ कि मैंने आईएएस में लॉ लिया था, मास्टर माने इफ यू हैव ए गुड नॉलेज ओवर द सब्जेक्ट, नॉलेज कभी वेस्ट नहीं होता है। आपको बताऊं, हमने अपनी जो पूरी तैयारी, मैंने कहा था आईएएस में लॉ किया था, तो उसकी पूरी तैयारी मुझे आज भी पे करती। आप जितनी अच्छी स्टडी अगर मास्टर ऑफ लॉ करके स्टडी करके, वो वाला नहीं, मैंने जो जैसे लोग एलएलएम की डिग्री ले लेते, उस पर मैं नहीं कह रहा हूँ, उस पर आई एम नॉट मेकिंग एनी कमेंट ओवर दिस। बट इफ यू आर डूइंग विद द लेबर, तो सर्टेनली सपोज करो कि आपने एलएलएम किया, तो जो नई फील्ड में ऊंचे तक पढ़ाई किया, वो आपको आज नहीं, हो सकता है कि आपको जरूरत ना पड़े, लेकिन आपको बेसिक लॉ में बहुत काम आएगा कभी कभी। और अच्छा नॉलेज है, कभी प्रेजेंट कर रहे हैं मुकदमे को, जैसे हम ही लोग हैं, हमने अच्छी स्टडी करके लॉ में आए, तो संविधान के प्रोविजन, सीपीसी, जो हमने संविधान में मुकदमे उस समय पढ़े थे, उसके लॉजिक डिस्कशंस किए थे, हम लोग रखते हैं, तो जजेस अप्रिशिएट करते हैं। ऐसा नहीं, आप लोग भी ऐसा करोगे। एलएम इज नॉट बैड, मस्ट डू, if you have chance you must go through. Okay.
सर, एक सीनियर एडवोकेट होने के नाते सर, आपका साइबर लॉ पे क्या विचार है सर? क्या यूपी में मतलब साइबर लॉ में बहुत ज्यादा स्कोप है या नहीं है?
अभी एक चीज बताएं आपसे, ग्रोइंग लॉ है, ग्रोइंग लॉ है, और साइबर क्राइम में देखिए हो रहा है जबरदस्त। जब क्राइम होगा तो उसके लिए एक्सपर्टाइज होगा तो अच्छे एडवोकेट जो होंगे उसके लिए फील्ड में आए। तो मैं तो कहता हूँ कि हम लोग को अपने यहाँ, आप लोगों को एडवाइस भी करूंगा, साइबर लॉ में आप लोग जरा अच्छा करिए। क्योंकि एक चीज बताएं, इट इज नाउ वेरी, इट इज डेवलपिंग लॉ। cyber crime in future, in fact 10 years back nobody know the cyber crime, cyber law की situation 10 साल पहले कोई जरूरत नहीं थी। आज बैंकिंग सिस्टम चल रहा है, आज आपका सब कुछ तो नेट सिस्टम से, ईमेल से सब हो रहा है। तो you must be well acquainted with the cyber law and it is a good opportunity in future। क्रिमिनल साइड में तो अभी हमारे पास आए तो मैंने बताया आपसे ना कि हम लोग कहने को तो बड़े वकील हैं, बेसिक्स नहीं मालूम है साइबर लॉ का मुझे। हम लोगों हमारे पास जो आए उसके जो क्राइम मैंने एसएसपी क्राइम थे मिस्टर राय साहब, उन्होंने बहुत अच्छी चीज ढेर सारे कोर्स दिए हम लोगों को, मैंने सबको बैठाया था। बहुत अच्छा चांस है, गुड चांस है। साइबर में है, इन्वायरमेंटल लॉज में है, अभी जो कई और भी नए नए हमारे जो डेवलपमेंट लॉ के हो रहे हैं उस सब में आने वाले दिनों में अच्छा चांस रहेगा। जी प्लीज।
सर मेरा ये क्वेश्चन है कि साइबर एक्सपर्ट होते हैं
सर,
जो पुलिस के जो साइबर एक्सपर्ट होते हैं वो क्या हेल्प करते हैं? जैसे वकालत करते वक्त अगर जैसे साइबर एक्सपर्ट से अगर कोई राय लेना हो वो क्या हेल्प करेंगे क्या?
आपको हेल्प क्या करेंगे अगर आप वकील के रूप में जाएंगे, लेकिन हाँ आप अपना स्वतः उनसे वो आपसे हेल्प लें, डेवलप योर नॉलेज टू द एक्सटेंट दैट दे मे कम टू मी, दे मे कम टू यू। हाँ हाँ उसमें करिए
सर।
थोड़ा सा जो हम लोगों के काल में अभी हम लोग भी इस पर जरूरत नहीं मुझे पड़ रही ज्यादा, लेकिन मैंने देखा कि ये जरूरी है। अगर अभी भी ये सब अगर हम इधर से हाई कोर्ट से छुट्टी पाते हैं, मैंने अपने जो इधर जो बार एसोसिएशन से, तो ये अच्छा लगा, इसको जानकारी होनी चाहिए, सबको जानकारी होनी चाहिए इसके बारे में। जो प्रॉब्लम आप बैंक से जुड़े हुए हैं, आप सारी चीजें मेल कर रहे हैं, सारी व्यवस्था, हम लोग थोड़ा लिटिल नॉलेज है हमारा, हम इस पर नहीं, हम आई एडमिट कि हम लोग उस फील्ड में नहीं थे, हम उस ग्रुप से नहीं अभी आ रहे हैं। लेकिन आप लोगों की समाज, जो आप लोग आने वाली 10 साल में जब पूरा समाज हावी हो जाएगा तो इसका रोल बहुत ज्यादा हो जाएगा। तो आप लोगों को इसका नॉलेज होना चाहिए, सबको नॉलेज होना चाहिए। आई विल आल्सो आफ्टर दिस माय टेन्योर एज ए प्रेसिडेंट बार एसोसिएशन, आई विल गो थ्रू द होल लॉ ऑफ दिस इशू।
ओके सर, थैंक यू
जी
सर एक क्वेश्चन है सर, जैसे जो सर जैसे सर हम लॉ कर रहे हैं सर, मेरे फैमिली बैकग्राउंड में सब लॉयर हैं, तो सर हमें किसी हमें अलग करना चाहिए, अलग प्रैक्टिस करनी चाहिए किसी सीनियर के साथ, कि सर फैमिली के साथ प्रैक्टिस करनी चाहिए?
अगर आप
केसेस
अपनी फैमिली के साथ करिए
सर, अलग नहीं कर सकते कि अलग अपना कुछ कर पाए बढ़िया तरीके से?
नहीं समझ रहे मेरी बात को। देखिए दो चीजें हैं, एक चीज मैं बताऊं कि हमारे यहाँ हाई कोर्ट में हायरार्की रूप में ढेर सारे चैम्बर हैं जिनके परिवार चल रहे हैं। आपका काम है आप अपने उसी इंथुजियाज्म के साथ काम करेंगे, यू विल डू द वर्क विद द सेम इंथुजियाज्म। एक बात है। दूसरी चीज है, आपके पास अपने काम के प्रति जिम्मेदारी होगी, आप लॉयल हो जाइए काम के साथ, तो अपने चाहे अपने साथ सीखे चाहे दूसरे के साथ करिए। इंडिपेंडेंट करने की क्या मतलब, क्या सकते हैं? अरे भाई आपका चैम्बर है, आपके भाई भाई हैं, अगर उनसे सीख लीजिए, सीख करके आप अपना आप शुरू कर दीजिए अपना काम, बुराई क्या है? पिताजी हैं तो आने वाले दिनों में आप ही को देखना है, तो आप इसमें रहिए, बुराई क्या है? आपको लगता है कि आप चैम्बर में कंट्रोल नहीं है, हम थोड़ा हमारी बातें हम नहीं सुन पा रहे हैं, तब आप दूसरी जगह ज्वाइन करिए।
सर और एक लॉयर, एक क्रिमिनल लॉयर की जो पर्सनल इन्वेस्टिगेशन होती है उसमें स्टेट का कितना साथ मिलता है एक लॉयर को? क्या ये इजी होता है या फिर इसमें कोई किसी तरह की परेशानियां आती हैं?
नहीं, आप जाइए अपना एडवोकेट एक्ट पढ़िए। एक हमारा क्रिमिनल है, जो एक आध दो केसेस अभी आ रहे हैं, आप लोगों ने सुने, वकील के खिलाफ भी कार्रवाई, वो जब पर्सनली देखिए, दो चीजें हैं, आपकी हमारी लिमिटेशन है, ये हमारे पास आया, हम आई हैव बीन प्रिविलेज्ड टू दैट एक्सटेंट, नो वन कैन, इवन द पुलिस कैन नॉट पुट अ क्वेरी टू मी कि ये क्या है। समझ रहे मेरी बात को? हम जब लीगल लाइन से आगे जाकर के सहयोग में आ जाते हैं, आई बिकेम द पार्ट, ट्रांजैक्शन में आ गए पार्ट, तब आपको प्रॉब्लम आती है। अदरवाइज किसी में क्रिमिनल में प्रैक्टिस करते हैं, 302 हमारे यहाँ कितने हैं, 302 बड़े बड़े जो क्रिमिनल हैं उनके पास आते हैं, वो आते हैं। और एक चीज ये भी बता दें, अगर आप अच्छे वकील हैं, अधिवक्ता हैं, तो चाहे आप कितना भी बड़ा क्रिमिनल के खिलाफ मुकदमा करते हो, आपको नमस्ते ही करेगा, वो आपसे डरेगा, वो जानता है। लेकिन बस अदरवाइज वर्क में मत जाइए, डोंट इन्वॉल्व इन एनी अदर एक्टिविटीज, पर्सनली डोंट बी इन्वॉल्व with his case, go on merit, do your work. It is up to judge who will take the decision, not you are not the judge. A, B, don't go on the personal issues of anybody. Be an advocate, do your best for your client, that's all. Please.
Sir, in advocacy में subject of philosophy reading is important or not?
What? Please, जरा आवाज तेज बोलिए।
Sir, subject of philosophy reading is important or not in advocacy?
नहीं, हम पॉइंट नहीं गेन कर पाए ब्रदर।
सर मतलब फिलॉसफी पढ़ना जरूरी है?
अच्छा, बने नहीं, आप मैंने कहते देखिए, एक आपने कभी किसी संत महात्मा के कथा उथा सुना है कि नहीं सुना?
जी सर।
सुना होगा ना। तो
जी सर।
रामायण जब आदमी कहता है, सुंदरकांड का जब पाठ करता है तो एक पाठ होता है, लेकिन उसका जब विश्लेषण करता है, जब उसकी फिलॉसफी उसके पीछे की जब तक नहीं होती तब कथा अच्छी नहीं होती। आपने सुन, पता चला आपको
जी
रामायण
सर।
का पता चला भागवत श्रीमद् भागवत की भी कथा आपको सुना दे रहे हैं, फिर गीता का उदाहरण दे रहे हैं, फिर कभी ऋग्वेद का उदाहरण दे रहे हैं। तो जब आपको इसके लिए फिलॉसफी, जैसे हमारे सर्विस में है तो सर्विस जो स्टूडेंट्स है उसको पढ़ लीजिए, आपको एविडेंस जो उसके पीछे बिहाइंड द बैक जो भी जुरिस्प्रूडेंस है इलाका, अगर आप जितना अच्छा पढ़े रहेंगे, यू विल बी द बेस्ट एडवोकेट, यू विल द बेटर एडवोकेट, यू विल बी द गुड एडवोकेट, योर डिग्री विल बी इन दिस मैनर। तो फिलॉसफी किसी चीज की बहुत अच्छी होती है अगर आप जानकार रखते हैं उस फील्ड की, व्हाट इज द थीम, व्हाट इज द रीजन, व्हाट इज द बैकग्राउंड, व्हाट इज द इंट्रोडक्शन ऑफ दिस थिंग। अगर ये सब आप नॉलेज, जैसे हम लोग ना पढ़ते हैं, अब आप जरा एक एग्जांपल बताऊं आपसे, एक वायरिस आप चैलेंज किए किसी प्रोविजन को, तो आपने अगर उसका प्रियम्बल की ये क्यों बना है आप ले गए, जैसे हम लोग कभी कभी जो डिबेट होता है, अपना जो कॉन्स्टिट्यूशन असेंबली बनी थी जब मैंने कॉन्स्टिट्यूशनल डिबेट हुआ था, तो हम डिबेट की जो वो क्या क्या बोले थे वो डिबेट खोजा जाता है। आपके पार्लियामेंट में क्या डिबेट इशू हुआ वो भी रखा जाता है कि ये थीम, इसके पीछे ये थीम है, इसके पीछे। अभी एक मैंने वायरिस चैलेंज कर रहा हूं, उसमें पर्पज कुछ लिखा हुआ है, ऑब्जेक्ट में अमेंडमेंट कुछ हो गया। तो अगर आप फिलॉसफी पढ़ेंगे तो यू विल बी बेटर। माने नॉलेज जितना अच्छा हो बहुत अच्छी चीज होती है, बुकिश नॉलेज नॉट वेरी नेसेसरी, इवन अदर साइड सराउंडिंग नॉलेज भी बहुत अच्छी बात होती है। प्लीज।
थैंक यू सर।
सर गुड इवनिंग सर। क्वेश्चन ये था सर कि इफ अ क्लाइंट
आवाज तेज लगाइए
सर, इफ अ क्लाइंट केम टू मी विद अ लीगल इशू that I knew was unjust, but the law supported. So what would I do in this situation, sir?
My senior was there. I was going with him because his chamber is just adjacent to the High Court. What he told me, he had told me that if you are strong in law, then give the fact and come on the law, you will get the justice. If you are strong in fact and the lie is slightly weak, then hammer the fact and you will get the justice. मतलब आप समझे, अगर कानून में आप स्ट्रांग हैं तो कानून बताइए, फैक्ट बताइए, जजमेंट ले जाइए। लेकिन कभी कभी जजमेंट हमारा वीक होता है लेकिन फैक्ट में हम इतना स्ट्रांग होते हैं कि जज क्या होता है आप समझिए, जज की ड्यूटी है कि फैक्ट पे कानून लगाए और न्याय करे, चाहे सिविल कोर्ट हो चाहे जहां हो। तो अगर आप फैक्ट में, जैसे आपको लगता है कि अन्याय मेरे साथ हो रहा है तो उसको इतना बढ़िया रखिए कोर्ट के सामने कि जज को लग जाए कि इसके साथ अन्याय हुआ, तो फिर जज अपने आप माननीय न्यायमूर्ति उसके कानून लगा के आपके पक्ष में ऑर्डर कर दे। तो ये फिलॉसफी रहती है एडवोकेसी की। I had also won one case in this issue. I was weak in law, but I was better in the fact. I got the success. The case is reported there. Excise का मैटर था, excise इंस्पेक्टर या कांस्टेबल का सिलेक्शन का मैटर था। तो वो भी दिस।
Thank you, sir. Thank you so much.
Please.
प्रणाम सर।
प्रणाम
सर, ये मेरा क्वेश्चन था कि जज जो है जहाँ विवेक का यूज करना होता है वहाँ पार्शियलिटी करते हैं कि नहीं? क्योंकि अभी केरला हाईकोर्ट का एक निर्णय आया था जिससे आर्टिकल 25 लगाया था उन्होंने कि ट्रिपल तलाक दे सकते हैं, जबकि हमारे यहाँ कानून बन चुका है पार्लियामेंट के द्वारा कि नहीं, ट्रिपल तलाक नहीं दे सकती है। इसमें क्या होगा?
नहीं, आपने अभी जो प्रश्न किया कि अभी एक्ट के पहले एक्ट नहीं था, तो हमारे यहाँ जैसे मुस्लिम पर्सनल लॉ में आपको तलाक का जो प्रोसीजर है उसके तहत आपने 3 बार तलाक माने उसका एक टाइम ड्यूरेशन करके बोल दिया तो वो डाइवोर्स माना जाता है। ये पहले ला था, अब हमारे यहाँ अमेंडमेंट हो गया तो इट इज नॉट वैलिड। आपको याद होगा कि पहले हमारे, देखिए, लॉ इज नॉट ए स्टैटिक वन, इट इज ऑलवेज रनिंग होता है। ये माने कोई रोकने, कानून या व्यवस्थाएं समाज कभी रुकती नहीं है। आप बचपन में देखे होंगे क्या था, आज क्या है, आने वाले दिनों में आप बुढ़ापे में देखेंगे क्या हो रहा है। ऑलवेज प्रोग्रेसिव होता है, लॉ इज ऑलवेज प्रोग्रेसिव हुआ करता है। कल को आप याद करिए, जब आप अभी नहीं पढ़ते हैं, जो उनका क्या नाम था, जो बाल विवाह, विधवा विवाह, इस सब पे कल एक जमाने में अपने यहाँ हिंदू लॉ में क्या था, विधवा विवाह नहीं कर सकते, लोगों ने अपोज किया। आज देखिए सक्सेसफुली काफी विडो मैरिजेज हो रही हैं, बाल विवाह का सब विरोध हो रहा है। तो ट्रिपल तलाक पे एक जो विषय आया था वो बड़ा हीनियस लगता है आपकी बने, जिसकी जो 3 तलाक का बात करता है, वो आदमी से जरा पूछिए उसकी लड़की के साथ ऐसा हो तो क्या हो, अच्छा लगेगा उसको? नहीं लगेगा। तो इसलिए वो अब आज की तारीख में वैलिड नहीं है। आप कह देंगे तो कानून के तहत उसमें कार्रवाई हो सकती है। अब तो उसमें क्राइम की भी व्यवस्था, माने इट इज ए क्रिमिनल ऑफेंस में करे तो कुछ सजा की भी व्यवस्था की गई। जी बोले प्लीज। Any more?
So one last question. So what are your views on the coordination between the bar and the bench, and what are the chances of one getting elevated from the bar to the bench? Like one very recent case of this, very recent example of this would be the Honorable Justice U. Lalit getting the CJI post.
Yes. May I just want to inform, in the High Court, there is a 2 mode of appointment in the High Courts. One direct by the High Court, and some earlier it was 20, now probably 30% from the lower court, means district judges are being promoted to that extent. And for the purposes, one thing I would like on this, that while promoting the judge of the High Court or of the Supreme Court, I request through your means also, and if some authorities are hearing this discussion, they must be very cautious. If the honest, transparent, diligent, and intelligent judges are not being appointed, system cannot go. So far in the state of UP is concerned, I would like to say that the procedure for elevation must be to the standard I have stated all of you. And one thing, therefore, there must be absolutely fairly. I'm saying I'm not happy with the whole procedure that is adopted by this. And I cannot make comment. You are young persons, you are coming in future, will take the knowledge of all these things. I'm not saying, but fairly I'm saying I'm not very happy with the procedure as adopted in the High Courts and its elevation. Merits are being not properly considered. Those who can give the best performance in the system, because in our High Court, you see, today we are in a strike for 3 days. Today it was suspended. There must be proper coordination between the bench and bar. Unless there is a proper coordination between the bench and bar, it is not possible to run the system. Now, because in this situation, as you have probably might have been gone through the paper, there was a abstaining. We are abstaining from work for 3 days. Today it was resolved between the bench and bar. New changes has come. By coordination, we have solved this problem. It will be removed. But one thing I would like to say, that there must be a proper coordination between the bench and bar, because we are the two sides of the same coin. Unless we are assisting properly, just cannot give the judgment, because in 1 second he cannot decide everything. If two advocates are sitting, they are giving plus and minus. Thereafter, he will decide that what is the correct position is there. Therefore, there must be a proper coordination on this.
Yes, thank you, sir.
Thank you. Should I close it? Or any more question? We should take leave of the... Yes, please.
Thank you, sir, for giving your precious time. We are grateful for your efforts you have put to share your thoughts and experiences, which will really be helpful for our career and skills. Your cognitive insights will help us with any field of law we will pursue. As being a law student, it is so required to present our thoughts aptly. We are really thank you, sir, and thank you everyone for joining this session. Now you may leave. Thank you. Thank you, sir.